Hello, it's Philip Taylor speaking from Richmond Green Chambers, and I'm looking at a book today from Wildy, Simmonds and Hill Publishing. It's in their insolvency series, and this one is called Personal Insolvency Practice, Litigation, Procedure and Precedents, and it's been written by Professor Mark Watson-Gandy. I'm very impressed with this book. My wife and I have written a review of it where we've given it the title Personal Insolvency, the key points on how to do it or deal with it. This is the book here. It's quite a wide book actually for a book. Green cover, there's the spine and there's some detail on the back. What you've got in the back of the book, just to start with, is some very useful toolkit information right at the back, because this is very much a hands-on book. There's no index as such. You've got throughout a whole range of very important points. For instance, you've got there the rules concerning insolvency rules themselves. And then if we go right to the front of the book, there are lots and lots of forms throughout, you can see there. And really it covers everything you need to know. There's the front cover there. There is in fact a short foreword, which is going to be referred to in a moment. And what I would advise you to do is to look under the actual contents themselves, as there's no index, to find what you're actually looking for, because you have a lot of petitions, forms and a lot of information that you would be looking for. For instance, you've got that sort of thing there, which is the witness statements. You've also got paragraph numbering at the sides, which I think does help try to find what you're looking for. You get a very good idea again there of the range of the information that is contained in this book. It's rightly described as the ideal starting point for lawyers, and what Watson-Gandy has produced is an excellent hands-on statement of how to do it when faced with the issue of personal insolvency. And as the Chief Bankruptcy Registrar of the High Court comments, that's Stephen Baister in the beginning, he says in the foreword, debt is as old as the hills. It certainly is, and its history goes back some 5 millennia apparently. However, bankruptcy itself has a more recent history set out in Roman times until we reach the modern legislation we now have in the Insolvency Act of 1986. The purpose of that act was to provide for the automatic discharge of debtors from bankruptcy after 3 years, and as we know, the Enterprise Act 2002 reduced the period to 1 year in most cases, making our bankruptcy regime one of the most liberal in the world. And what's been achieved here is a practical explanation of the central proposition we have today. The debtor obtains his discharge and release from his bankruptcy debts in exchange for the disclosure of information about his financial affairs, and of course the surrendering of his assets to his trustee to enable the assets to be released with a view to paying a dividend to the creditors where that can be done. And this book goes together with a corporate insolvency book to give practical guidance to the reader on bankruptcy processes. The chapter headings, each with short indexes at the front, are cleverly designed to explain in the simplest way how to deal with the main problems the debtor is faced with. That I think is very useful both for lawyers and for litigants in person. It's about 400 pages long, and it ends with a short chapter on the appeals process, and lastly a toolkit section which I showed you right at the back. The only thing missing, as I say, is an index, so you do need to use the contents section at the front. But I'd like to thank the author and the publishers for producing what is an excellent contribution, and in my view a first-class book for both the professionals and for the very, very worried litigants in this difficult area. Thank you. Bye-bye.